Today we're going to talk about adequate protection in bankruptcy. Typically, whenever we talk about adequate protection, we are referring to secured creditors in bankruptcy and the payments that secured creditors are entitled to receive from the debtor or trustee in exchange for the debtor or trustee's use and or possession of that collateral. So what is adequate protection? Adequate protection is really just what it sounds like. It is to adequately protect the secured creditor for the diminution in value of its collateral that is caused by the trustee or the debtor's use of that collateral. So in other words, the trustee or the debtor could be in possession of different kinds of collateral. Collateral such as personal property, that means equipment, other types of personal property like inventory. It could also mean accounts receivable. The debtor could also be in possession of real property. And all of these kinds of collateral require different analysis when we talk about adequate protection. For example, real property in normal market conditions appreciates, and therefore adequate protection may not be the same as it would be with regard to accounts receivable. Accounts receivable, if used, meaning collected, turned into cash, and then spent, dissipates very quickly and becomes valueless after it is used. So those two different kinds of collateral require different kinds of protection. Sometimes the adequate protection can be similar, but that helps to paint a picture of the different types of collateral when we talk about adequate protection. So let's talk about what kind of adequate protection might be necessary for accounts receivable. One of the typical things that a debtor will do is grant a replacement lien in new accounts receivable that are created by the use and collection of the previous accounts receivable. It also might require, and typically does require, some sort of payments. So the most typical form of adequate protection is to be paid. Other forms of adequate protection could include new collateral. So maybe the debtor has a piece of real estate that is unencumbered and is unable to make payments to the secured creditor, so they grant the secured creditor a lien on that new collateral. It also might mean new liens on different asset classes. It should always mean insurance. In order to adequately protect a secured creditor's interest, the collateral should be insured. If the debtor does not provide the secured creditor with adequate protection, and adequate protection to an extent that it protects the diminution in value. So if the collateral is depreciating at a rate of $1,000 per month, then the secured creditor should receive adequate protection in the amount of at least $1,000 per month. If the secured creditor does not receive adequate protection, then that is something that the secured creditor should file a motion to seek relief from the automatic stay to recover its collateral. And unless that collateral is necessary to an effective reorganization, not receiving adequate protection should be grounds to receive relief from the automatic stay to recover that collateral.
Adequate protection is the assurance that secured creditors are entitled to receive from a debtor or trustee as compensation for the debtor's use of and the decreased value of its collateral. Types of collateral: personal property, such as equipment, machinery, or inventory; cash collateral, such as cash and cash equivalents, accounts receivable; real property. Different kinds of collateral require different analysis when determining adequate protection. For example, real property appreciates in normal market conditions, while accounts receivable becomes valueless after it is spent. If the debtor does not provide the secured creditor with adequate protection, then the secured creditor should seek relief from the automatic stay to recover its collateral. We hope you have enjoyed this episode of the 5-Minute Legal Master series, where expert, board-certified attorneys help you master today's important legal topics.